My intentions today is to talk about, give you background on our court system, how it affects evictions and housing, and to basically just shed some light on things that, as a background information, that folks may not actually be all that aware of. So the name of this presentation, Justice and the Poor, Americans' Broken Legal System and its Impact on Housing Stability. Justice and the Poor is something I stole from a book that was written in 1919. That was the very first book about our justice system and how it impacts the poor and how it mistreats the poor in America. And that book changed the world's view, at least in the legal system, back in 1919, and it really started the legal aid movement in large part. It was written by a man who ran the Boston Legal Aid. Anyway, so that's where Justice and the Poor actually came from. When our children are in grade school, if they learn anything besides the song Happy Birthday, they learn the Pledge of Allegiance. And if it's anything like an American creed, it's the Pledge of Allegiance. Everyone in America has memorized the Pledge of Allegiance. And when we say the Pledge of Allegiance with our hands over our heart, I expect that we all sincerely mean the words that we say. And we end with the phrase, with liberty and justice for all. And that's the promise we make to our grade school children. That's the promise we make to Americans, that our country offers liberty and justice for all. This quote is from Lewis Powell, a Richmond, Virginia lawyer who went on to become president of the American Bar Association and then went on to be on the Supreme Court of the United States. And therefore is probably one of Virginia's greatest jurists since John Marshall. He had these eloquent, beautiful words to say about this. And I'm going to read it to you because they're beautiful words. Equal justice under law is not merely a caption on the facade of the Supreme Court building. It is perhaps the most inspiring ideal of our society. It is one of the ends for which our entire legal system exists. It is fundamental that justice should be the same in substance and availability without regard to economic status. Paints a beautiful picture of our legal system. But there's alternative views of that system. Reginald Heber Smith, when he wrote Justice and the Poor in 1919, said this: without equal access to the law, the system not only robs the poor of their only protection, but it places in the hands of their oppressors the most powerful and ruthless weapon ever created. Those are strong, strong words. And when you hear the words oppressor, you might be rolling your eyes and saying, oh, come on, come on. I will tell you, in my presentation, you will feel that oppression. And another more modern view of our legal system. This is from California Court of Appeals Justice Earl Johnson. He said, yeah, poor people have access to the American courts in the same sense that the Christians had access to the lions when they were dragged into the Roman arena. Very different views of our legal system, depending on where you sit. Well, The Virginia Supreme Court's Administrative Office did a survey of Virginians a few years ago. And this is their chart. This is the results of their survey. And they asked Virginians, just, random sampling, what sort of treatment do you think the following groups of people receive in Virginia courts compared to other groups? So how are people like you generally treated compared to other groups? And it came out, yeah, about the same. And then the next column over, what about men? Maybe a little better. What about women? Maybe not quite so good. What about African Americans? And you can see somewhat worse treatment, doubled. Then what about Hispanics? About the same as African Americans. What about non-English speakers? How are they treated in Virginia's courts compared to everybody else? That was a little worse. But then the next to last column, they asked, how are the poor treated in Virginia's courts? And the bottom drops out. The consensus is clear that the poor are treated much worse in Virginia's courts than everyone else. This is just Virginia citizens answering a survey from the Supreme Court. And then the last question, just for comparison, how do you think the wealthy are treated in Virginia's courts compared to everybody else? And you can see the contrast. So, let's back up. Equal justice under the law is probably tied to the impact of having an attorney in the courtroom. Our system of justice relies on the adversarial model, with each side capably and zealously represented by counsel. And when we have that, then we have a peerless system for arriving at the truth and applying the law fairly. It really is a wonderful system, and it works great when you have that model. Both sides zealously represented by capable lawyers. It's a beautiful thing. But there's a flawed premise in that system. It's designed on the premise that all litigants are going to be represented by attorneys. If that were true, Lewis Powell's vision would be the right one. The court's rules of procedure, evidence, requirements for the way pleadings are drafted, even the very language used by the courts, legalese, presumes the presence of an attorney who's graduated from law school and passed a rigorous bar exam, and presumes that for each litigant. So that's a serious design flaw, if you will, in our system of justice, because many users of the court system can't afford a lawyer. Now, the United States Supreme Court recognized the injustice of this back in 1956. They said there can be no equal justice where the kind of a trial a man gets depends on the amount of money he has. Very true. That's what that survey showed from Virginia. And then a few years later, the United States Supreme Court put its money where its mouth was. In the landmark transformational case of Gideon versus Wainwright. It was such a big case, they even made a movie about it, Gideon's Trumpet, starring Henry Fonda. And in that case, the United States Supreme Court said there was a constitutional right to a lawyer if you could not afford one. Amazing change in the law. But they put one little loophole in there. That only applies to criminal cases. So if you're accused of a crime, can't afford a lawyer, as you've all seen the people being read their Miranda rights in court in the cop shows, you get a court-appointed lawyer. But if you're not accused of a crime, you just have an honest civil legal problem like anyone else, there's no court-appointed attorney. And that happens to be America's biggest misconception about our civil justice system. Just this last summer, a Harris poll of Americans, 2,000 Americans, asked them this question. And more than half of all Americans, 56%, mistakenly think they have a right to an attorney in a civil case. Another 18% just didn't really know. Only a fourth of Americans knew that you don't have a right to a lawyer in a civil case. The biggest misconception in America about our system of justice. And when I'm, on behalf of my organization, asking for funding from a locality, for instance, and I tell them there's no right to a lawyer, they look at me like I'm lying to them. They look at me like I'm from Mars. Of course that's not true. It is. It's the truth. And that's why nonprofit charities, not government agencies, but charities like Blue Ridge Legal Services were created to try to fill that void that our Supreme Court has not yet found a right to. So, what do things look like when you don't have a right to a lawyer and you can't afford one? The ABA came out with this survey a few years ago, the National Center for State Courts. Across America, not just Virginia, across America, only the plaintiff was represented in 2/3 of the cases. Both sides were represented only in about a fourth. Now remember, the ideal system, the way that our courts were designed to function was when both sides were represented by counsel. That's only true in less than a fourth of the cases in America. In 2/3 of the cases, there's this serious power imbalance where the plaintiff, usually a company, someone of means, has a lawyer, and the defendant, usually someone without means, does not have a lawyer. And you have this imbalance of power that wrecks our system of justice. Well, what about in Virginia? So I've been on this Virginia Access to Justice Commission for about 10 years. And when we first met, we have like justices from the Supreme Court on there. I asked, well, how many unrepresented people are there in Virginia's courts? And he said, well, we don't know. I said, but you're the court. Wouldn't you know? Well, we don't track that. So I got them to start tracking that. And then after they tracked it for a year, I got a grant to do a survey of their data. And that survey, which was compiled by the National Center for State Courts, was published 8 years ago. And the results were startling to anybody who wasn't poor or doesn't work at legal aid. It found that ideal situation where both sides are represented in Virginia's general district courts happens in 1% of the cases. Only the plaintiff is represented in over half. Neither side is represented in 45%. You have a court system that's designed for lawyers, and in only 1% of the cases does both sides have a lawyer. The study also found that poverty is a great indicator of whether or not someone's going to be represented or not. Yeah, common sense would tell you that, but they had an empirical study with statistical correlationships to determine that. So, low-income Americans, Virginians, can't afford a lawyer, even for serious civil legal problems that could threaten ruinous results, particularly in Virginia, particularly when they're threatened with evictions and possible homelessness. So let's go back. When one party can't afford a lawyer and the other side can, the system no longer functions correctly. The normal level playing field is tilted, despite the best efforts of the court. The judge sitting up there with one side with a lawyer and the other side without can't become the unrepresented litigant's lawyer. So what does the judge do? What is the result of that imbalance? So a Harvard law professor wanted to find that out a few years ago. So he did a gold-plated statistical study with randomized sampling. So statistically, it's just unassailable. In Boston, he found that represented tenants were able to keep their homes in 2/3 of the cases. Wow. He found that unrepresented tenants were able to keep their homes in evictions in only 1/3 of the cases, which essentially means there was an error rate of 1/3 in those cases where the defendant didn't have an attorney. An error rate of 1/3. That's pretty damning. That's not a system of justice. That's pretty arbitrary. Well, you might say, well, that's just Boston. That's just one study. Here are 11 other studies. These studies have been taken across the decades from different courts in different states, and they have different results. But the one theme that's clear in every one of those studies is that if you're represented, your odds of winning significantly higher than if you're not. And these were all eviction cases and the tenants, whether they were going to be able to keep their homes or not. All 12 studies clearly show, without a lawyer, your chances of beating the eviction are much lower than if you have a lawyer. So that study we got done of Virginia's court data a few years ago. This is another graph. I love graphs, sorry. This is another graph of all the cases that were completed by General District Court in 2016. And the blue shades were where the plaintiffs won, and all the other colors were where they didn't. And it's amazing. It's almost perfectly split, 50-50. You think, hey, that looks pretty fair, 50-50. Then you take that exact same data, you break it down by representational status. Plaintiffs only represented, neither party represented, both parties represented, only the defendant represented. And you can see the results vary dramatically, depending on the balance of power and whether you're represented or not. And these are evictions in Virginia. Unrepresented tenants were evicted in 63% of the time. Represented tenants were evicted in only 43% of the time. A discrepancy of 20%, an error rate of 20% in Virginia's courts based on the court's data. And then I persuaded the Legal Services Corporation to update that study, and they released their report just 3 months ago. And they found that looking at court data in Virginia over the last 5 years, that landlords, 85% of the landlords in Virginia who are filing evictions were corporations, corporate entities. Only 13-14% were ma and pa landlords. 85% corporate landlords against renters. They found that tenants rarely have representation in Virginia's courts, and only 1% total, while the landlords represented in over 2/3 of the cases. And this is, again, showing representation rates. Last year, in 2023, tenants were represented in just under 1% of the cases. They broke this data down by legal aid section. Blue Ridge's area had the highest representation rate in the state. 2%. Yeah. The study found that represented tenants were 7 times more likely to win than unrepresented. And gratuitously, they found that legal aid lawyers did better in eviction cases than private attorneys. Just saying. So, you're the judge. You've got a represented tenant, a represented landlord, and an unrepresented tenant. And they're both going to present their case. And you have to decide the case based on what they present. And the landlord's lawyer has polished their case up great. It's a shiny diamond. And the unrepresented renter comes in as just an ugly rock of a case. They don't know how to polish their case and present their case. Their case looks not so great, particularly compared to that shiny diamond of a case that the landlord's lawyer has presented.
And
So,
a lot of the times they're afraid to even speak up, so they may even have a good case.
oh yeah,
So when the judge asks for comment, they say nothing.
they don't know what to say. That's right. They're just like a rock.
Right.
They're wrong.
Yeah.
So in this case, this picture actually depicts a zirconian diamond, a fake diamond. And the rock there happens to be one of the most priceless diamonds ever found in America. It just is an uncut diamond in the rough. And that could be exactly what that tenant has. They have a great case, but they don't have a lawyer there to present it. So the judge has to go with what the judge sees in front of them. Go for the shiny diamond. And I think that means there is an implicit bias against unrepresented litigants. And let me go on a tangent and talk about that for a second. You know, when judges are trying their best to rule the right way, I mean, of course they are. They're not going to intentionally rule for the weaker side. They're going to rule for what is right, what the law says, what the facts show. They're going to do their best to rule the right way. Otherwise, how in the world could they go to bed at night and go to sleep if they didn't think they had ruled the right way on every case they had seen that day? So when they see this data that says, oh, well, in a third of those cases, you probably ruled wrong because one side didn't have a lawyer. Their mind is going to explode. And they'd say, no, they didn't have a good case. That's what it is. They didn't have a good case, and that's why they lost. Not they didn't have a lawyer. They didn't have a good case. So I made a presentation that included some of this data to the Roanoke Bar Association a few years ago. And we were trying to get lawyers to agree to do pro bono work. And I had the judges there, the circuit court judges, the chief judge there at the end, they were going to say, come on, guys, let's do pro bono, right? That was the plan. So I did my presentation. And then the chief judge got up and said, yeah, you know, it'd be good if y'all did pro bono work. These unrepresented people, you know, they're going to lose, but they'll feel better if they had a lawyer with them.
That's great.
Missed the whole point. The moral of the story, lawyers hold the key to the courthouse. And without a lawyer, you're locked out of our system of justice. These studies, all these graphs, all this data confirms what common sense tells everyone. You need a lawyer in order to safely navigate our court. And if you're poor and can't afford a lawyer, you're effectively locked out of our system of justice. And despite the best of intentions of any judge who's trying their best just to rule the right way, it's impossible to have a fair trial with a tilted playing field when one side lacks representation. So that's one powerful bias against renters in Virginia when they don't have a lawyer. There's going to be an error rate against them of 20 to 30%. But there's another kind of bias in our courts that comes from that. So think about this. Let me back. Judges don't know every law. They don't know every case. You can't expect them to. The way our system works, when both sides have a lawyer, each side's lawyer explains to the judge the law that supports their side of the case. And then the judge hears both sides, gets a good understanding of what the law is both ways, and then with that education, can make a decision. Well, suppose in certain kinds of cases, there's always just a lawyer for one side and never a lawyer for the other side. Landlord-tenant cases, creditor-debtor cases, certain kinds of cases where there's already a power imbalance. One side always has a lawyer, the other side never has a lawyer. Then multiply that by years and years and years and decades and decades. Judges always hearing just the law that favors the landlord and never hearing the law that favors the tenant. And the judge is going to learn the law and think that's all there is to the law. It's kind of like a plant. A young plant you set in front of a window, and it grows, and you never turn it, and so it grows towards the light and gradually hardens in a misshapen form towards the light. Same way with the law and judges when they only hear from one side of the case. So let me give you a few examples of that from Stanton, Waynesburg, Augusta County in my career as a lawyer. So my very first year as a lawyer, we had a tenant come in and said, I'm renting a mobile home and I'm behind my rent, and the mobile home lot owner has turned off my utilities. And we knew that there was a law, the Mobile Home Lot Rental Act, that said they could not do that. It was against the law. So my mentor, Peter Messett, filed a motion for an injunction, bill for injunction, and filed it, and we rushed down to the court to have a hearing on this injunction. And we went into the judge's office. Judge Moffitt, wonderful judge, kind of elderly then, but highly respected, very nice guy, smart, a model judge. So we're in there explaining this to the judge, and Peter is reading from the Code of Virginia. And Judge Moffitt says, let me see that. He takes the code and he reads it. Then he turns it around to read the spine. To see, it really was the Code of Virginia. Because he had never heard of that law. It had been on the books for 5 years. He had never heard of it. Why? Simple. Mobile home renters couldn't afford a lawyer to go into court and say, there's a law. So, to Judge Moffitt's credit, he gave the book back, looked at the landlord and his lawyer, and said, looks like these boys have a point, and entered the injunction. So that was to his credit. He got it exactly right, even though he had never heard of that law before. Moving to Stanton. I had a client come in, and like I said, in my first year of practice, and they said the sheriff came to my house and levied on all my stuff, and he's going to sell it. And it was stuff like, basic stuff like clothes and things. I said, well, I looked at the code and said, well, but that's supposed to be exempt from levy. Oh, the sheriff levied on it. So I wrote the sheriff a letter and said, it looks like one of your deputies inadvertently levied on stuff he wasn't supposed to levy on. I just want to bring this attention. Maybe you could release it, and then everything will be fine. If not, we're going to have to file something to challenge this in court. I tried to be really, really polite. The morning after he got that letter, he calls me at home at 7:30 in the morning, livid, yelling at me. What are you doing, threatening me? Just trying to point out I hadn't done the law right. Nobody had ever challenged what they had done before. So when we went to court on this, the sheriff was over there watching the judge, and the judge very, very tenderly said, yeah, that's what the law is. But you can't do this. And there was an attorney general's opinion issued as a result of that says, no, you can't be doing that. Now, why was that just a shock to that sheriff? Because for decades, before legal aid came to town in 1980, for decades, there had never been anybody representing someone who was getting their property levied off because they couldn't pay a debt. So the sheriff did what they did, and nobody ever challenged it. So they thought what they were doing was right. Then my favorite story from back in the day, in Waynesboro. Again, that first year in practice, I was scared to death most days. A young woman, a young unmarried woman with a small baby, came in and said, I was behind in my rent in my apartment. And when I came back, from my grocery store, whatever, the front door was padlocked. And there was a note on it from the sheriff saying that he had padlocked my door. And I can't get in. And all my baby's clothes, formula, food, everything's inside the apartment. And we're locked out. I said, well, have you been to court? No. I said, well, that's weird. That's not the way the law's supposed to work. So I called the sheriff. I said, I'm not quite sure I understand. He said, what do you mean? That's the way we always do it. And who are you? So then I called the Commonwealth's attorney who represented the sheriff and said, I don't understand. I think this is wrong. So we're confident that what we're doing is legal. So I filed for an injunction in Waynesboro Circuit Court to see Judge Goad, who I never laid eyes on before because I was a brand new lawyer, and called the other side and said, we've got a hearing tomorrow morning, 9 o'clock. And that afternoon, just before 5, the Commonwealth's attorney called me and said, we've taken the padlocks off the client's door. She can go back in. And from that day to today, 44 years later, they haven't padlocked anyone in Waynesboro. How did that happen? Because people who couldn't pay their rent couldn't afford a lawyer. Before legal aid came to town, there was no one to say, this is illegal. So a few years later, I was in Waynesboro General Court for something else, and a bailiff came up to me after the court and said, aren't you the guy that made us stop padlocking? I said, yeah, that was me. He stuck out his hand and said, I want to thank you for doing that. I felt terrible locking people out. But that's what we thought we were supposed to do because nobody had ever told us it was wrong. So that's oppression, systemic ingrained bias, just because for decades, one side never had a lawyer and the other side did. And it perverted our legal system. Here in Waynesboro, here in Stanton, here in Augusta County. And all it took was a green lawyer, didn't know anything, to say, hey, I think this is illegal, for that system to be challenged. Thousands of cases every year in Virginia have potential for an unjust outcome, depriving the poor litigant of rights, money, housing. This institutional bias has developed over the years. The law has become deformed sometimes. Individuals, families are ground into poverty, and their legal problems become almost insurmountable barriers from ever escaping poverty. This lack of access to legal services and to justice results in generational loss of wealth and a disrespect for the rule of law because it's unfair. So, going back to that book, Justice and the Poor from 1919, Reginald Heber Smith, I'm going to read this beautiful words, forgive me. Nothing rankles more in the human heart than the feeling of injustice. It produces a sense of helplessness, then bitterness. It is brooded over It leads directly to contempt for law, disloyalty to the government, and plants the seeds of anarchy. The conviction grows that law is not justice and challenges the belief that justice is best secured when administered according to law. The poor come to think of American justice as only containing laws that punish and never laws that help. They are against the law because they consider the law against them. That's the indictment of our system of justice 105 years ago. It's better. But then again, a few years ago in the streets of Ferguson, this came home to roost. You know, it shouldn't be controversial or unusual for low-income tenant to have a lawyer who asserts defenses, right? But when I started out, I'm sorry for going back to the old days, when I started out, judges and other lawyers were hostile to a legal aid lawyer. Now, I was born and raised in Stanton, went to UVA college and law school, came back home just to represent my neighbors. But I was an outsider troublemaker because I was representing poor people who had never had a lawyer before. Now, happy to say, over the last 45 years, that's changed. It has changed completely. The old judges who were hostile to legal aid and viewed us as just disrupting their court docket have retired. Some of them changed their minds. New judges came on. Judges who have been lawyers who practiced with legal aid, against legal aid, and respected legal aid, knew what legal aid lawyers, people representing poor people, brought to the table, a level playing field. And now we're considered an essential part of the court system. Judges, we do surveys sometime, and judges invariably report that our legal aid lawyers are doing excellent work when we appear before them. So yeah, as a matter of fact, some of the judges are former legal aid lawyers now. So yes, that's been a real improvement over the 45 years of my career. Now, our very landlord-tenant laws passed by the General Assembly have had their own bias. Not only do you have the bias from lack of representation and the bias of institutional deformity of the law over the years, but then the laws themselves generally have favored landlords over tenants in Virginia's history. Most of the landlord-tenant laws originally were just how you evict people and how you collect your rents. And never talked about what rights tenants might have. And why would that be? Well, most of the members of the General Assembly back then were landlords. So, you know, there weren't many tenants in the General Assembly. And who could afford a lobbyist to lobby the General Assembly for the passage of legislation to change things? Large landlords and property management associations, certainly not tenants. So our laws started out stacked up. Very first change came about in 1972. There was a National Conference of Commissioners on Uniform State Laws promulgated a uniform residential landlord-tenant act. It was supposed to be balanced, treat both sides fairly. It was good work. A couple of years later, the Virginia General Assembly took it up. They stripped out all the powerful things that favored tenants, and then they said, and it's only going to apply to apartment houses. It's not going to apply to landlords who have fewer than 10 units. And so we had this dichotomy of old law and new law. And some of the old judges, they didn't want to let go of the old law. They would assume the old law applied and fight you like hell if you tried to insist the new law might apply, because it gave tenants rights they weren't happy to give. That's gone away. That dichotomy is gone. We now essentially have the same law for almost everybody. And in the last decade, there have been some significant improvements. protecting tenants. And they have made a sea change in how these cases can be litigated, particularly if the tenant has a lawyer. And now there's organizations down in Richmond who are lobbying on behalf of tenants and actually getting some good laws considered by the General Assembly. And there's still some room for improvement. Two things. So a tenant who's being evicted for non-payment of rent, and they lose in General District Court, they cannot appeal that case to circuit court unless they pay all the rent that the judge said they owe before they get to appeal. Everybody else, every other kind of case in Virginia's courts, if the person can't afford an appeal bond, they get to appeal without paying it. But tenants accused of not paying their rent cannot. And so if you have a judge who knows that, that judge can rule any way they want to, and there's nothing to be done about it. You can't appeal it. A judge can be a monarch, a tyrant, and there's no recourse. That's a real frustrating thing, and that needs to be changed. Second, and that's been proposed, but it's been defeated up to now. Another change that would go a long ways is during the pandemic, there was a temporary law that said instead of a 5-day pay or quit to start an eviction, you have a notice that says you have 5 days to pay or quit, to pay your rent, or I'm going to evict you. The law was changed temporarily to say you have 14 days to pay your rent before I evict you. And the rationale behind that was lots of people are a week or 2 weeks away from a paycheck that they can pay the rent if you just give them that extra time. The 14 days was designed to give them time to get to the next paycheck and pay the rent, and then you don't have to worry about an eviction. And that was the law in Virginia for, about a year, and then that expired, and now we're back to a 5-day pay or quit, and evictions are going back up. Now, right now, there was a bill that's passed both the House and the Senate in the General Assembly right now. It's on the governor's desk. The same bill was on the governor's desk last year, and it was vetoed. So I expect that it will be vetoed again this year. But those two issues.
14 days. Is that the law on his desk? It gives 14 days.
Yes.
Okay.
Yes.
And then, John, on that first one, is there any way you can do an escrow account so that somebody could fund that until it's appealed?
Well, not only do you have to post the full amount that you already owe, but then you have to pay into escrow an amount equal to how much your rent's going to be pending the appeal. So poor people just don't, in a rent case, just don't have a right to appeal. But hey, we have legal aid. Why is there a problem? And yes, that is Tiny Tim. Why is there a problem when we have legal aid? Well, this chart basically tells you all you need to know. I took the number of lawyers who are licensed in Virginia and divided that into Virginia's population and found that there's 371 Virginians for every lawyer. So every lawyer in Virginia has basically a client pool of 371 people. Then I took the poverty population of Virginia, divided that by the number of legal aid lawyers in Virginia, and you get 4,596 clients per legal aid lawyer. 14 times. That's why we have legal aid, but there's still a problem. There's just no way we can represent. And believe it or not, we bust our butt to represent tenants, and we managed to get 2% of it. Last year, 71% of low-income households experienced at least one civil problem, whether it was domestic violence, veterans, disability, housing conditions, healthcare. 71% of low-income people. 86% of them couldn't get the legal help they need. And that's true across Virginia and true across the United States. So, what does it matter? These issues involve the most fundamental issues of any society, the most basic of human needs. It's about families and family stability. It's about child custody, it's about child support, it's about adoptions, it's about guardians. It's also about personal safety, protection against abuse. It's also about keeping a roof over your head, protections from evictions, foreclosures. It's about health and food, subsistence. It's more than just corporate needs. It's about respecting human dignity. It's about asserting and protecting legal rights for people who can't afford to pay for it. Equal access to justice nourishes spirits and souls. It gives people faith that our nation's solemn pledge of justice for all is alive and real, and not just some cruel illusion. And it gives people hope that they can get a fair shake in our justice system. But if justice for all is going to be more than just an empty phrase at the end of the Pledge of Allegiance, we need to recognize that our system of civil justice is broken, built on a flawed premise, and that it's critically important for the health of our democracy that we fix it. For evictions, for every other kind of case that low-income people face in our civil courts. I'm going to close on the highest authority I could find. In the book of Proverbs, speak up for those who cannot speak for themselves. For the rights of all who are destitute, speak up and judge fairly. Defend the rights of the poor and needy. And then lastly, from the book of Proverbs, the righteous care about justice for the poor, but the wicked have no such concern. Thank you. A couple minutes if you've got questions, I can try to answer them. Yes, sir.
Can you explain the 2130 law? Can you explain the 2130 law regarding eviction?
Yes, so under Virginia law, if there is a breach of the lease, a material breach of the lease, that can be remedied, the tenant can change it, then the landlord is required to give that tenant a 2130-day notice that says, you've breached this lease, this is what you've done, you have 21 days to rectify it. If you do, great, we're done. If you don't rectify it, then your lease terminates in 30 days. So that's a 2130-day.
But if they don't pay, they can be evicted in 14 days?
But for non-payment of rent, it's a different rule. 5 days, and you're out.
Seems like destroying an apartment's a lot more expensive than failing to pay rent. It seems to me that destroying an apartment is a lot more expensive to the landlord than missing out on 2 weeks of rent.
Right. Yeah. Yeah, they should. I mean, if they can do a non-payment case, they should, as opposed to 2130. And then if they do a 2130 and they fix it, but then the same condition comes up again, they can do a 30-day notice, I think, if they've done that twice, and not have to do it over. But anyway. Yes?
John, I think you were modest in your description of the 3 cases you experienced because you went in and got an injunction, and, if the person had gone and filled out one of those little complaint forms, put it in at the court, who knows how long, so, and going for an injunction to get the person back in that day is impossible for a non.
No, an unrepresented person would never be able to do that.
Yeah.
I didn't have a clue what I was doing, but I could figure, would.
You had your bar card.
I had my bar card and got in there enough to make a difference.
You guys still have to go in for injunctions?
But that's still an option, yeah.
You got your votes up to.
Well, I enjoy talking about it. I love talking about this stuff. It's been my life, but I love sharing that with people, particularly because I think the light needs to be shed on some of these things. People just don't know, unless you're involved in it on a daily basis, and then you're all too well. I appreciate you coming to hear that. Yes, ma'am.
Certainly enjoyed doing fantasy and your heart of compassion. And it is a blue already.
So, yeah, Blue Ridge covers from Winchester to Franklin County, Rocky Mountain. Okay, so 25 cities and counties. We have 16 lawyers. Yeah.
So the justice system changed because they know it's a need based on the popularity of the population of the poor and the disadvantaged.
There's a lot of lip service. With not much.
And fewer donations.
What is your funding?
I'm on the commission for access to justice with members of the Virginia Supreme Court. And they know this is a terrible thing. But they don't have the money. The General Assembly has the money.
Is your funding strictly from private donations?
No, we get funding from the federal government, state government, from donations, from localities, from United Ways, from community foundations, everywhere we can scram up some dollars. Scram.
I know how that
I'm a
is.
full-time scrammer.
In fact, you can go to our website right now. Under the Justice for All donation.
Yeah. You've got paralegals and stuff too, though. Do you have people that?
We don't have paralegals, that help our lawyers. We end up paying them almost as much as we pay.
Yeah.
So we go with it.
How many volunteers do you have?
So, I think last year, maybe 200 lawyers helped volunteer across those 25 cities. And they donated, half a million dollars to legal services. Yeah. It's about 8% of the lawyers. They're doing pro. We can double that, it'd be great. Sort of arguing that.
Would you say the tricky thing for pro bono attorneys is that they don't often practice law, so they're unfamiliar? It's limited what you can handle.
Yeah, private attorneys learn the law that makes money. Now, our clients aren't the ones who put us in.
I know zero about my part-time, but I can still learn.
So we're just to honor full time for our lunch break. We'll do a soft closing, and we'll let Anna make a concluding remark.
Oh.
And then we'll ask Ms. Deborah Freeman, as long as it's okay. I know John has another meeting. We don't want to hold him up to that too as well. So we'll have you can go ahead and do the closing remarks. Then you may have time for 1 or 2 more questions after.
In close. Thank you all for coming. Thank you to Deborah for your and your staff. Same district website, and then there's links to housing materials as well to look at that. But one of the things that came up in that study was about our aging housing stock and the need for housing repair services, and that's going to be our focus of our next lunch tomorrow. It'll be the same library. So we're going to have that as a topic. In April, we're going to focus on our public schools and the services provided to housing insecure. Through that, I'm not sure when that will be happening in April. And you can check us on housing website, Facebook page. We are going to be reporting these and kind of giving them a series. So if you want to come back and review some things that John said, you should be able to see that recording and share it with other folks as we move forward. You'll find on the tables and the Miriam has a totally that was upside down. So your space papers, you can find that resource information on the Jackson County website, and then there's a little card about the next lunch program coming up. This is February in March.
Can you post John's slides?
I believe that would be one of the class.
Good.
That is the one. So I think we're good. Anything that I missed in my closing remarks? Okay.
Right, thank you.